Trump just had his entire financial empire frozen in the middle of the night. A federal judge issued an emergency order at 3:17 a.m. Eastern Time, locking down bank accounts, investment portfolios, and business assets totaling an estimated $2.3 billion. And this wasn't some routine court proceeding or scheduled hearing. This was an unprecedented middle-of-the-night judicial intervention triggered by evidence so urgent that a federal judge broke protocol to convene an emergency session while most of Washington was still asleep. When a sitting federal judge calls lawyers into court at 3 a.m. and issues financial freeze orders before the sun comes up, you know something absolutely catastrophic just detonated in the legal system. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this extraordinary midnight judicial action? According to court documents filed under seal at 11:43 p.m. on January 29th, federal prosecutors presented evidence of alleged asset transfers totaling $847 million that occurred in the previous 72 hours. Sources with direct knowledge of the filing say prosecutors argued these transfers represented a systematic attempt to move assets beyond the reach of pending legal judgments and ongoing investigations. This isn't speculation or political theater. Multiple news outlets have confirmed that Judge Patricia Ramirez, a George W. Bush appointee with 19 years on the federal bench, personally reviewed the emergency motion and decided the evidence was so compelling that waiting until normal business hours posed an unacceptable risk to the integrity of multiple ongoing legal proceedings. The order itself, portions of which were unsealed this morning, uses language legal experts are calling extraordinarily blunt for a federal court document. Here's what we know happened in those crucial midnight hours. At 11:47 p.m., prosecutors from the Southern District of New York filed a 47-page emergency motion under seal. The motion reportedly included bank records, wire transfer documentation, and communications between financial advisors discussing the urgent need to restructure holdings before certain legal deadlines. By 1:23 a.m., Judge Ramirez had reviewed the sealed filing and ordered both prosecution and defense teams to appear via secure video conference. Sources tell us that defense attorneys were given exactly 90 minutes notice, an almost unheard of time frame that signals just how urgent the court considered this matter. The hearing itself began at 2:58 a.m. and lasted approximately 73 minutes, with the judge issuing her freeze order at 4:11 a.m. before the first news cycles of the day had even begun. Smash that like button if this is making sense so far. Here's where the legal situation gets absolutely explosive. The emergency order doesn't just freeze personal bank accounts. According to the unsealed portions, it covers 23 separate financial entities, including corporate accounts, investment funds, offshore holdings, and even certain real estate transactions that were in progress. Legal analysts reviewing the order say the scope is breathtaking, effectively paralyzing the financial operations of multiple Trump-affiliated businesses until further court proceedings can establish proper oversight and accountability. A former federal prosecutor who reviewed the documents told reporters this morning that she's never seen an asset freeze this comprehensive issued against a former president or major political figure in American history. Now let's talk about what led to this moment, because this didn't happen in a vacuum. For months, legal teams across multiple jurisdictions have been tracking financial movements that they believed represented attempts to shield assets from court judgments. The $454 million civil fraud judgment in New York, the $83 million defamation verdict, and several other pending cases have created a complex web of legal obligations. But what allegedly changed everything was a series of transactions that began on January 26th. Bank records reportedly show that starting at 2:47 p.m. that Sunday afternoon, a coordinated series of wire transfers began moving funds from accounts that had been subject to court monitoring into newly created corporate entities with complex ownership structures designed to obscure the ultimate beneficiaries. Here's what multiple sources say happened next. On January 27th, a forensic accountant working with one of the plaintiff legal teams noticed unusual activity in court-monitored accounts. She immediately flagged the transfers to lead counsel, who spent the next 18 hours tracing the money through what they describe as a deliberately convoluted network of shell companies and offshore accounts. By the evening of January 28th, they had assembled what they believed was clear evidence of a systematic effort to move assets beyond legal reach. That's when they made the decision to file an emergency motion rather than wait for the next scheduled hearing, which wasn't set until February 12th. The legal team argued that every hour of delay increased the risk that assets would become permanently unreachable, leaving court judgments essentially unenforceable. And here's where it really gets serious. When Judge Ramirez reviewed the evidence in that middle of the night hearing, sources say she focused intensely on one particular aspect of the transfers. Communications between financial advisors included in the sealed filing reportedly contained explicit references to moving assets before pending legal deadlines and discussions of jurisdictions that would be most resistant to U.S. court enforcement actions. One message, according to sources who've seen the filing, allegedly stated that they needed to complete restructuring within 96 hours to stay ahead of court monitoring systems. That kind of language in financial communications transforms what might be routine asset management into potential obstruction of justice and contempt of court. Drop a comment right now if you saw this coming. I read every single one. The judge's order itself contains language that legal scholars are calling remarkably direct for a federal court ruling. One unsealed paragraph states that the court finds substantial evidence of deliberate attempts to frustrate the enforcement of valid legal judgments through systematic asset concealment and transfer. That's not the kind of language judges use lightly. It's an explicit judicial finding that the transfers weren't normal business operations, but rather calculated moves to evade legal obligations. Former federal judges interviewed this morning emphasized that for a court to make such findings in an emergency order without a full evidentiary hearing signals that the initial evidence must be extraordinarily compelling. Now things get absolutely wild. The defense team's response in that 3 a.m. hearing has itself become a source of legal controversy. According to sources present during the video conference, defense attorneys argued that the asset transfers were routine corporate restructuring unrelated to any legal judgments, and that the emergency motion was politically motivated timing designed to generate negative publicity. But here's where their argument apparently fell apart. When Judge Ramirez asked why routine corporate restructuring required completion within a 96-hour window and why it coincidentally occurred immediately after recent court deadlines were set, sources say the defense response was notably evasive. One attorney reportedly claimed that the timing was purely coincidental and driven by tax considerations, but when pressed to explain which specific tax deadlines required action in late January, he could not provide a coherent answer. This isn't the first time courts have frozen assets in high-profile cases, but the circumstances here are genuinely unprecedented. Think back to the Bernie Madoff case when federal authorities froze billions in assets overnight. But that involved criminal fraud charges and a defendant who had confessed to running a Ponzi scheme. Or consider the Enron executives whose accounts were frozen, but again, that came after criminal indictments and extensive grand jury proceedings. In this case, we're dealing with civil judgments and potential contempt issues, yet the court has taken action typically reserved for the most extreme criminal matters. That tells you something about how seriously the federal judiciary views the alleged conduct. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. Legal experts are now drawing comparisons to the Saturday Night Massacre during Watergate, not because the underlying conduct is identical, but because both represent moments when the legal system had to act decisively to prevent the erosion of judicial authority. When a president or former president takes actions that courts believe undermine the fundamental enforceability of legal judgments, judges face a stark choice: act decisively to preserve judicial authority or allow the legal system to be rendered meaningless for powerful defendants. Judge Ramirez clearly chose the former. So what allegedly triggered this unprecedented judicial response? According to legal and financial experts who reviewed portions of the unsealed order, the transfers violated fundamental principles of court jurisdiction and judgment enforcement. The documents reportedly show wire transfers to accounts in jurisdictions with limited reciprocal enforcement agreements with the United States. These weren't transfers to standard domestic banks or even to friendly foreign jurisdictions with strong legal cooperation agreements. Sources familiar with the analysis say several of the recipient entities were established in countries specifically chosen because they're known to be resistant to U.S. court orders and difficult jurisdictions for asset recovery. Here's the kicker. The order reportedly includes specific findings that some transfers were structured to fall just below reporting thresholds that would trigger automatic bank notifications to authorities. Multiple transactions in the $9.8 million to $9.9 million range, according to sources, when the automatic reporting threshold is $10 million. That kind of precise structuring isn't accidental. It's sophisticated financial maneuvering designed to avoid detection and oversight. Legal experts point out that structuring transactions to evade reporting requirements is itself potentially illegal, separate from any questions about evading court judgments. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone, regardless of political affiliation. This isn't just about one person or one set of legal cases. If defendants in major civil cases can freely move billions in assets beyond court reach the moment judgments go against them, the entire civil justice system becomes meaningless. Courts can issue all the rulings they want, but if there's no ability to actually enforce those rulings against wealthy and sophisticated defendants, we have a two-tiered justice system where legal judgments only matter for people who can't afford complex asset protection schemes. This puts Republican officials in an extremely difficult position. On one side, they face pressure from a base that views any legal action as politically motivated persecution and expects unwavering defense regardless of the underlying facts. That means attacking the judge as biased, questioning the legitimacy of the civil judgments themselves, and framing the asset freeze as government overreach. On the other side, they're forced to reckon with a federal judge appointed by a Republican president making findings of systematic asset concealment based on banking records and financial communications. They now have to explain why asset transfers timed to evade court enforcement represent legitimate business operations, a position that becomes harder to defend as more details emerge. And here's the tricky part for the legal defense team. There's really no innocent explanation for the pattern of transfers. Either the timing was purely coincidental, which becomes statistically implausible when you're talking about dozens of transfers all occurring in a 72-hour window immediately after court deadlines were established, or the transfers were deliberately timed to stay ahead of enforcement efforts, which is exactly what the court found. The middle ground position that this was just routine financial management without any connection to pending legal matters requires ignoring the timing, the destinations, the transaction structuring, and the communications between advisors. Legal and constitutional scholars are calling this a critical test of whether the rule of law applies equally to everyone. A Yale law professor and former clerk to Supreme Court Justice Anthony Kennedy told news networks that if courts cannot enforce civil judgments against politically powerful defendants who have the resources to engage in sophisticated asset protection, we've effectively created a legal exemption for the wealthy and powerful. While defendants have every right to appeal judgments and contest liability, they don't have the right to make themselves judgment-proof through asset concealment while those appeals proceed. A former federal prosecutor added that the alleged conduct could potentially cross the line from aggressive asset protection into criminal obstruction and contempt. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even conservative legal scholars who generally support broad executive immunity and presidential authority are notably quiet on this issue. The asset freeze doesn't involve presidential powers or executive immunity questions. It's about whether any defendant in a civil case, regardless of position or status, can systematically move assets to frustrate court enforcement. That's a principle that transcends political ideology because today's victorious plaintiff could be tomorrow's frustrated defendant if courts can't enforce their own judgments. So let's break down what this could mean going forward. First, the immediate legal impact is severe. With $2.3 billion in assets frozen, the ability to fund ongoing legal defenses, pay business operating expenses, and maintain liquidity for various enterprises is dramatically curtailed. The freeze order reportedly allows for limited exceptions for ordinary business operations and legal expenses, but every dollar spent now requires court approval and financial transparency. That level of judicial oversight is something typically reserved for defendants in criminal racketeering cases or trustees managing bankruptcy estates, not for former presidents managing business empires. Second, it creates a massive evidentiary problem for any future legal proceedings. Courts can now subpoena records of every transaction that occurred during the freeze period, every communication about asset management, and every financial decision made. That paper trail becomes evidence in potential contempt proceedings if courts determine the initial transfers were designed to evade enforcement. The defense argument that there was no improper intent becomes much harder to sustain when prosecutors can show the court a comprehensive record of exactly who authorized what transfers, when, and what the stated justifications were. Finally, looking ahead, the political implications are profound. Every Republican candidate now faces questions about whether courts should be able to enforce judgments against politically powerful defendants, or whether sufficient wealth and political support should place someone beyond the reach of the civil justice system. Campaign ads are already being prepared featuring small business owners and ordinary citizens, asking why they have to pay court judgments when powerful political figures can allegedly move billions offshore. This creates a fundamental fairness issue that transcends typical partisan divisions because respect for court authority has traditionally commanded bipartisan support. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal and political fallout, this is really about fundamental constitutional principles. Courts are co-equal branches of government with the constitutional authority to interpret laws and issue binding judgments. If their orders can be systematically evaded by defendants with sufficient resources and financial sophistication, judicial authority is effectively nullified. The implications for the separation of powers would be catastrophic because an executive or former executive who can simply ignore civil court enforcement creates a precedent that undermines the entire constitutional structure. This scenario is causing sheer panic within certain Republican circles. Reports indicate that emergency conference calls have been held to determine messaging strategy. Some argued for attacking the judge's credibility and questioning whether a 3 a.m. hearing provided adequate due process. Others insisted that defending asset transfers to offshore accounts in the middle of the night is political suicide, especially when bank records and communications will eventually become public. The party is fracturing in real time between those who believe any criticism of Trump equals betrayal and those who recognize that defending systematic asset concealment is legally and politically untenable. Meanwhile, the core supporter base is absolutely furious at Judge Ramirez. Social media has exploded with calls for her impeachment, accusations of judicial overreach, and conspiracy theories claiming the entire proceeding was orchestrated by political opponents. To the base, this is the ultimate proof that the legal system has been weaponized against their preferred political figure. They view the 3 a.m. timing not as a sign of judicial urgency, but as evidence of suspicious motives and coordinated political persecution. Stay with me. What comes next will completely change how you view the situation. Here's what makes this even more extraordinary from a legal procedure perspective. The judge's order includes provisions requiring daily financial reporting, meaning that every 24 hours, detailed accountings of all asset movements must be filed with the court. Legal scholars point out that this level of ongoing judicial supervision is virtually unprecedented outside of bankruptcy proceedings or criminal asset forfeiture cases. It transforms the relationship between the defendant and the court from the normal arm's-length civil litigation into something much closer to active judicial management of financial affairs. The order also reportedly includes what's called a clawback provision, meaning that if the court ultimately determines that the transfers were improper, it retains authority to void those transactions and require the return of assets, even if they've moved to third parties or foreign jurisdictions. International law experts note that actually enforcing such provisions against assets in non-cooperative jurisdictions is extremely difficult and time-consuming, but the legal authority exists and has been successfully exercised in major fraud and embezzlement cases. The very existence of the clawback provision signals that the court believes it may ultimately need to reverse transactions that have already occurred. Here's what the legal team is up against now. They have several options, none of them particularly attractive. They can appeal the freeze order to the Second Circuit Court of Appeals, arguing that Judge Ramirez abused her discretion in granting such sweeping relief without a full evidentiary hearing. But appeals courts typically defer heavily to trial judges on emergency orders, especially when there are findings of systematic evasion based on documentary evidence. They can try to negotiate a modified order that unfreezes some assets while maintaining court oversight, but that requires acknowledging the court's authority and cooperating with judicial supervision, which may be politically unacceptable to the client. Or they can fight the order head-on, refuse to comply, and force a contempt showdown, which would lead to sanctions, possible criminal contempt charges, and the very real possibility of incarceration for contempt of court. That nuclear option essentially bets that political support will protect against judicial enforcement, a wager that has historically not ended well for defendants who directly challenge federal court authority. Judges jealously guard their institutional authority, and a defendant who openly defies a federal court order typically finds that judges across the political spectrum unite to defend judicial power. If this blows your mind, hit that like button right now. Here's the current situation as of this morning. A federal judge has frozen an estimated $2.3 billion in assets after evidence emerged of systematic transfers to offshore accounts and complex corporate structures allegedly designed to frustrate court enforcement. The freeze order requires daily financial reporting and gives the court ongoing supervisory authority over asset management. And this all happened in a middle-of-the-night emergency hearing called because prosecutors argued that every hour of delay increased the risk that assets would become permanently unreachable. This is no longer just about civil judgments in fraud and defamation cases. It's now about whether courts can enforce their own orders against defendants who have the resources to engage in sophisticated international asset protection schemes. When a federal judge takes the extraordinary step of convening an emergency hearing at 3 a.m. and issues a multi-billion-dollar asset freeze before dawn, we've entered genuinely unprecedented legal territory. If there are no consequences for systematic asset concealment, it signals that court judgments are optional for defendants with sufficient resources and financial expertise. Keep a close eye on this story because the next 72 hours are absolutely critical. The defense team has until 5 p.m. Eastern Time today to file any emergency motions seeking modification or stay of the freeze order. Banking institutions holding the frozen accounts have been ordered to provide complete transaction histories going back 120 days by Friday morning. And Judge Ramirez has scheduled a status conference for Monday morning where she's expected to address long-term management of the frozen assets pending final resolution of the underlying cases. Legal experts say that status conference could provide the first public details of exactly what the sealed evidence shows. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. A federal judge has taken the extraordinary step of freezing billions in assets after finding substantial evidence of systematic transfers designed to evade court enforcement. Financial institutions are being ordered to provide comprehensive records of recent transactions. The legal defense team faces a deadline to respond within hours. And legal scholars across the political spectrum are watching closely to see whether the civil justice system can actually enforce judgments against politically powerful defendants. This isn't just another legal proceeding that will fade from headlines in a few days. This is a fundamental test of whether courts are co-equal branches of government with enforceable authority, or whether sufficient wealth and political support can place defendants beyond the reach of judicial power. The evidence is under seal, but portions are being released. The freeze order is in effect and being enforced by financial institutions. Now we wait to see if the rule of law still means anything when applied to the powerful. The stakes have never been higher, the legal implications have never been more severe, and the constitutional crisis has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage. What happens in the next few days could determine whether our civil justice system can function equally for everyone, or whether we've created a two-tiered system where judgments only matter for those without the resources to evade them. Stay subscribed because this story is just beginning and the most explosive revelations may still be ahead.